I'm Jessica from Leverage Legal Group, and I want to ask you something. Have you ever posted a trending audio clip, a meme, or an image on your business's Instagram or TikTok? If so, you could be one DMCA takedown or one copyright complaint away from losing that post or even your entire account or facing a copyright infringement claim. I know it sounds extreme, but copyright law applies just as much to your social media content as it does to your website and your marketing materials. And today I'm going to break down what founders and business owners must know to stay out of trouble and protect their brand online. So let's talk about what copyright actually protects first. Copyright covers original creative works, and that includes a wide range of things, but it does include photos, videos, music, audio clips, graphics, text posts, illustrations, etc. So basically, if someone created it, it's automatically protected the moment they hit save. So when you share that image, remix that video, use a trending sound or audio, you are technically using someone else's copyrighted work. And if you don't have permission, that's technically copyright infringement, even if you gave credit. So understand something. Credit is not license. Giving credit does not equal permission. So let's clear up a few of the biggest myths that I see, founders talking about or perpetuating. Myth number one, it's online, so it's free to use. Well, that's not true. Just because something is publicly visible doesn't mean it's in the public domain, meaning available to use however you want. The creator still owns it. I mean, really, when you think about it, if you were to go to a museum and you, as a member of the public, were able to see a painting hanging on the wall, that doesn't give you the right to take the painting off the wall and take it with you, right? It's owned by somebody else. Well, the same is true with social media. Myth number two, if I modify it, I can use it. So changing colors, cropping, or adding your logo does not make it yours. It's still derivative use, which means derived it from somebody else's creative work, and that still requires permission to use it. And a permission is usually in the form of what's called a license. We'll talk about that in a minute. Myth number three, it's fair use. I see founders love to throw that term around without really understanding what it is. Fair use is actually very limited, and it's reserved mostly for commentary, criticism, parody, or education. Commercial use, like marketing your business, generally not going to be fair use. Okay, so what happens if you don't follow the rules? First of all, your post can get taken down under the DMCA, which is the Digital Millennial Copyright Act. And if that happens repeatedly, your account can be suspended. And if a creator wants to take it further, they can actually sue you for copyright infringement with damages that can reach up to $150,000 per work if the content was registered. Okay, so let's just take a second and talk about what the Digital Millennium Copyright Act is. What is the DMCA? It is a US law designed to protect copyright owners in the digital age. It basically extended the Copyright Act into the digital realm, and it gives creators and copyright holders the ability to send what are called takedown notices to websites, platforms, social media companies, etc., to quickly remove infringing content. And that's why you sometimes see videos, reels, or posts suddenly disappear. It's generally because a DMCA notice was filed against that post and against that account. But here's where it gets serious. If you're found to have violated the DMCA, meaning you used copyrighted material without permission, you can still be hit with what are called statutory damages under the Copyright Act, ranging from $750 per infringement to $30,000 per infringement. And an infringement is usually each time you publish or reshare something. So it's not just one fine, it could be a multiple of those numbers. And if the infringement is found to be willful, meaning you knew that it was not your content and you knew that you were using it without permission, that amount can jump up to $150,000 per infringement. And courts can also order you to pay that copyright owner's attorney's fees and costs that they incurred in going after you, which can make the total financial hit enormous, even for something you thought was just a quick post. And by the way, often these lawsuits can come years later after you have shared the work. And so you're not safe if you don't get a takedown notice right away. So while you might think it's just social media, the legal exposure is very real, especially for a business account. So let's quickly talk about how to stay compliant. How do you stay on the right side of the law while still engaging shareable content? Here's what I tell my clients. Number one, use licensed or original content. So I would stick to music, images, and videos you've created yourself, or use licensed libraries. There's lots of them out there. Canva Pro has one, Envato, Adobe Stock, etc. Just make sure you read the license terms and make sure that it allows for commercial use, because if it doesn't allow for commercial use, you don't have the right to use it. And let me explain, I'm not talking about reposting. Like if you're just sharing, like retweeting or reposting somebody else's content, that's not a copyright violation. I'm talking about when you create a post of your own, but you are using somebody else's copyrighted material in your post. Okay, so secondly, be cautious with trending sounds. So TikTok and Instagram Reels often use popular songs or movie clips, but those are always going to be copyrighted. So for personal accounts, platforms may have limited use licenses, but those often don't apply to business profiles. So if you're posting from your brand or business account, check the rules first and make sure that you're not in violation of those rules. And then number three, protect your own content. So if you're a creator, the first thing you must do is register your original videos, scripts, graphics, songs, etc., photography with the US Copyright Office. The reason this is important is that it's only if you have a registered copyright that do you have the right to enforce your ownership rights, remove infringing copies, and collect damages if necessary. So you must register your original content for real, tangible protection. And then four, include copyright clauses in your contract. So if your marketing team, social media manager, or creative agency produces content for you, your contracts must clearly say that you, not them, own the rights to what they're creating for you. Otherwise, they could legally own your brand's visuals and copies. And that type of agreement is called a work for hire. I've done videos about that specifically here. So go find those if you want to understand, how to do that more effectively. But you need to make sure you have that in place when you're getting materials created by someone who's a contractor and not a W-2 employee in your business. So why does this matter? Social media is where your brand lives. Your visibility, your credibility, your customer connection. Losing content or facing a copyright claim can cost you not only money, but also time, reach, and trust. The good news, with the right registrations, securing the right licenses and contracts, you can post confidently knowing that your brand is protected. If you're not sure whether your content strategy is legally protected, or if you're using AI tools, for example, contractors, trending media, let's talk. I help founders and business owners protect their brand assets, their social content, and their creative work so they can focus on growing and not worrying about takedowns or lawsuits. So just schedule a call with me and we'll review what you have, review what's at risk, and how to fix it before it becomes a problem. You've worked hard to build your brand. Let's make sure no one can take it from you.